to curb the illegal bulldozer demolition. 2044 2024 का जो जजमेंट है सुप्रीम कोर्ट का, गाइडलाइंस टू कर्ब इलीगल बुलडोजर. मुस्लिम इंडिविजुअल्स accused जहांगीरपुर कम्युनल वायलेंस और बुलडोज्ड बाय अथॉरिटीज घर तोड़ दिए थे उसको इलीगल बुलडोजर. ऑफ द होम ऑफ मुस्लिम मोटरिक्स का बुलडोजिंग घर को कर दिए थे. एक्शन had been taken after Muslim tenants on had stabbed a Hindu classmate. Bulldozer demolition of the nature AMU Aligarh Muslim University. Supreme Court overruled 57-year-old precedent set by 5-judge bench. Minority status of AMU Aligarh Muslim University does not have a minority status under Article 30. Aligarh University does not have a minority status under Article 30. University does not. Aligarh Muslim University नहीं था. University legislation AMU Act 1920 4.3 majority in the present case. The court held that institution incorporated by legal instrument can have majority status if the founder was a person from the minority community. Put down specific parameter to determine the minority status of the any religious or linguistic educational institution established under Article 30. Article 30 under does not have any minority status. Aziz Basha had found that Aligarh Muslim University, Aziz Basha, it was established through a union legislation, AMU Act, Aligarh University, 1920. 4.3 majority in the present case. In the court held the institution incorporated. The court held the institution incorporated by the legal instrument. A minority status if the founder was person from the minority community. It also put down specific parameter to determine the minority status of religious linguistic education institution established under Article 30 under. First time when the Supreme Court of 75 years laid down the indicators, the parameter will assist a smaller branch. AMU is a minority institution or not. They are also likely to be applied on another case. Present case is the court after AMU decided to reserve 50% seat in postgraduate or medical courses for Muslim candidate ପାଇଁ 50% seat होची seat for postgraduate medical or Muslim candidate ପାଇଁ AMU University. These are also likely to be applied on another case reserving the seat for student from particular community to reserve ରହିବ. As a material resources. In the constitution bench matter that it is one of the longest pending Supreme Court of the 9 judges bench. 9 judge bench को फैसला करते हैं. To significant question. These are significant. Article 31C continue to exist the constitution after the decision of Minerva Mills versus Union of India. 1980 Minerva Mill case 31C होची रिपील होइथिला राइट टू प्रॉपर्टी. तर प्राइवेट ओन्ड प्रॉपर्टी होची प्राइवेट जो प्रॉपर्टी मटेरियल रिसोर्सेस ऑफ कम्युनिटी. आर्टिकल 39B ऑफ द कॉन्स्टिट्यूशन. 5 नवंबर 2024 9 जज बेंच unanimously held Article 31C continued to exist in the constitution. Provision protected law of advance directive principle exercised under the Article 39B. This means that any law enacted to give effect to wealth redistribution, संपत्ति का redistribution principle 39BC cannot be challenged on the ground of violate fundamental rights. Challenge नहीं हो सकता. Judge held not privately owned property was material resources of the community. Private संपत्ति किसी का material resources. The majority led by the CJ Chandrachud reasoned that private property could be material resource. Nationalization, acquisition, if the court held that private property was a material resource of the community.